My name is Darla Dee Fletcher, and I live in Bonner County. I would like to read an email that I find really disturbing because I think it refutes some of what happened and what was said today. This was written from Jake Gabel on March 21st, and it was to the three of you, as well as copied Bill Wilson. Attached is a request by the Planning Department to establish a moratorium on minor land divisions and family exemption applications. The details and rationale are found in the attached document, along with the proposed ordinance, relevant state statutes, and taking analysis. The idea and the details of the request were a joint effort between myself and Bill Wilson. At this time, we do not want to amend the published agenda, as this may result in an increase in applications for these file types prior to the BOCC taking action. Bill requested that the board amend the agenda at the beginning of the meeting and add this as an emergency request. I generally make myself available to answer questions from the BOCC regarding pending legislation, but in this case, I've spoken with Commissioner Domke at length regarding this item earlier in the week. To avoid serial meeting and any allegations of open meeting law, I think it best to refrain from any communication in person or in writing regarding this request until it's brought before the board on Tuesday. And I'm sorry, but that really sounds like you guys were hiding and trying to avoid us knowing so that we could come and talk about it. And I feel like that was underhanded, and I appreciate that you're trying to cure it now. But it sounds like I'm not sorry for what I did, but I'm sorry I got caught.
To clarify, first and foremost, if the board believes or any members believe that in fact there is a risk to public health and safety, which I did, then it is correct per statute to, as it indicates in 67-6523, the governing board may then proceed without recommendation of a commission upon any abbreviated notice of hearing that it finds practical to adopt the ordinance or moratorium. As was stated earlier by Mr. Wilson, if you believe, which I did, and I still do, that this current process is harmful to our community, and if you allow a flood of additional applications to come in to then exacerbate that harm, then that would be a bad decision, which is exactly why the statute allows that action. And that is why I took that action. You can disagree with that decision, but that's the reason I made that decision. So to indicate that there was some other intent is false. I also want people to understand that communication that Director Gabel mentioned in his communication with me is accurate. As the liaison from the board to the planning department, he speaks with me about items and issues that he's planning to bring before the board for feedback prior to doing so. Our discussion was about whether a moratorium on MLDs and family exemptions was something that I agreed with. It made sense. And by having that conversation with only one member of the board, it complied with open meetings law. We did not discuss at any time the only communication about the issue of doing this as an emergency action without prior noticing came in that email. So there were no communications between he and I in our conversations prior to or between the time of that email and the actual meeting that took place about the idea of putting it on the agenda as an emergency item. So you may have whatever opinion you wish, but you need to have the facts to form that opinion.